into the declaratory order. Sorry, I'm going to kiss myself. It's so complicated. Just a minute. I can
I don't believe this letter was in your packet, so I'm just going to read it. And I know some of the board members are, might not be familiar with this process. This is a letter from the Pelican Institute, who I see is represented here today. So I'm going to let them do their presentation, but they wrote to follow up on a petition for declaratory order that was dated September 18, 2024. It's been on our agenda multiple times. There were actually 5 licensees that requested the same order. The licensees' names: Amy Cao, Linda Ho, Hien Huang, Jan Thao Nguyen, and Vic Dong Bo. You may recall that after we received the petition for declaratory order, we sent a letter to the Attorney General requesting an opinion, because this is not typically the type of declaratory order that the board would receive. It did not deal with the scope of practice. It dealt with whether or not particular laws or rules comply with the Constitution. And since constitutionality is something that is typically decided by the courts, we requested clarification for the Attorney General. Unfortunately, we have not received a response. The Attorney General did ask for some clarification of our request. I did send a written speak with them and also sent a written clarification for request, but I still have not received an opinion. So in a declaratory order situation, we generally allow the requester to present any argument, evidence, whatever they want to present. I was informed by Ms. Harbison, and I'm going to let her speak for herself, that they were not presenting any evidence. So I'll just maybe let her do the presentation of whatever her position is to the board to explain.
Sure, that's accurate. I really don't have a presentation. I think the letter that we sent, or what we sent last fall, speaks for itself, as well as this letter. So I don't really have anything to add. I don't want to take up your time. I think that's accurate. We've just asked to move the process along. It's been about a year.
Is there anybody else here that wants to speak on the declaratory order or the declaratory request, or any of the licensees here? So it's my legal opinion, though I am not the Attorney General, that the board does not have the authority to issue, to interpret what is being asked to be interpreted. So if the board is in agreement with that, I can draft up the order. The order is going to have to go to, because it's being issued after January 1st, 2025, and this board joined the Occupational Licensing Review program at the Attorney General's office. Any orders that are issued have to be approved by the Attorney General's office. So I can draft up the order, and it has to be approved by them before the order can actually be issued. So I can draft up the order. Our chair is not here today, and she can, if she is okay with the order, we can send it for review, and then as soon as I get that review back, I would let the board know that it's being issued. Do any of the board members have any questions? Does anybody have any objection with drafting an order in line with what I said?
I have never seen one piece of paperwork on any of it besides this, so I don't really want to say whether. Okay. I don't even know what the declaratory order says.
So I have it with me. So they're all basically the same, but as I said, there were 5 licensees that submitted this request. It might be better if Ms. Harbison explained what their request is, because I don't want to misinterpret what the substance of the request is. Do you mind if I pull it up?
Yeah.
If I could just briefly, the question that we presented, I just went straight to the question presented, is whether or not the individuals who we named were, whether they have a right to a trial by jury, rather than the board being judge, jury, and executioner for these individuals. It's, do they have a right to a trial by jury under the U.S. and Louisiana constitutions? That's just the quick and dirty summary.
Okay.
And some of these violations, the licensees, the violations that we're dealing with are pretty old. One of them, the first one, which I have right here, is from 2014. So these are the cases that were already adjudicated. They're not there's no pending cases with these individuals. And most of them were resolved by consent.
Okay.
So the part of the request that might be most helpful is on page 4, the question presented. I think is what Sarah was just relating. And then right under the question presented, there's a section called licensee's position, and that's kind of is a summary of their position. Everything that precedes, that's more background and legal concepts. So under the question presented, the question is whether the individuals or entities have a right to a trial by jury. And so my concern has been, since we received this, as to whether the cosmetology board has the authority to decide that. It's my position that that question can only be decided by a court of law. So I think that's what our Constitution requires, and I did send that information to the Attorney General's office and asked them to look at it. My recommendation would be to advise that the board does not have the authority to determine whether or not a right to a trial by jury is required. My understanding is that the board has to follow the laws as written unless there's a declaration by a court of competent jurisdiction otherwise. And I'm not aware of any determination by a court of competent jurisdiction that a fine of $20 by a licensing board or a consent agreement by a licensee requires a trial by jury. And that's one of the reasons I asked the Attorney General for some information, if they had some additional information to add. Yes, I would want the board to authorize the draft of the letter, but like I said, because January 1st we joined the OLRP program, we don't really have authority to issue an order without approval of the OLRP anymore, if it impacts the licensee. So there's a form that we fill out for the OLRP, and it goes to them and would actually come back here with or without their approval. So it's kind of a process. But I can start that process if the board desires to do that. Or do whatever the board deems appropriate. I mean,
No, just a little bit.
Agree. Go through the process.
okay. And unless there's any objection.
Couldn't hear the statement.
He said, whatever.
Couldn't hear the statement was just made.
How long that we wait and then the Attorney General decides the process?
So just so I'm clear, you are recommended that we wait until the Attorney General answers our pending request.
That is correct.
Not reach out to the OLRC.
Just wait.
Is there a second and a vote?
I said. All in favor? All opposed?
I would request that it just be added to the next agenda in case we do get a response. And I'll just report
Oh, yes, please.